Stuart McCullough. I'm the CEO of VHIA. And it's time for this week's Industrial Roundup. And starting this week with community health. Community health members will be aware that the regulations accompanying the Long Service Benefits Portability Act have been approved and released. We did note a positive change with respect to those regulations in terms of the double dipping concerns that we had raised. We're currently reviewing those regulations further. Community health members can also expect that the July IR report will arrive this week ahead of next week's HR/IR manager meeting. In terms of health services, we're currently consulting with regards to the draft log of claims applying to the Replacement Nurses and Midwives Agreement. Bulletin 2456 contains a schedule for consultation prior to the finalisation of that log and its submission in final form to DHHS on 19 July. The log has been prepared on the basis of the feedback that members have submitted to VHIA during the life of that agreement. Our broader industrial relations strategy to reduce complexity through greater commonality across our agreements, and the matters that are identified in the state government wages policy. The draft log will be issued to CEOs on 11 July after we've incorporated feedback from the reference group. There will be a go-to meeting session on Monday 15 July for CEOs or their delegates, with final feedback due on Tuesday the 16th of July. Just a reminder for members that further information with regards to bargaining and our bargaining strategy is available in earlier podcasts. Specifically, more information about the development of the log of claims is available in podcast episode 110, the state government wage policy in episode 105, the VHIA Enterprise Bargaining Framework in episode 103, and bargaining in 2019 more generally at episode 95. And just a quick reminder to members that Yammer has replaced the VHA Community app and will be utilising the Yammer network for the purposes of the meeting-by-meeting updates that will occur during bargaining. For those of you who participate in various reference groups, we'll be reminding you to accept those invitations prior to those meetings occurring, and we would ask that you make sure that you do accept that invitation prior to coming to those meetings. It's all intended to make sure that people are comfortable and familiar and hooked up to that platform before things get really busy and bargaining commences. And that's it for this week's Industrial Roundup. It's now time for the weekly update.
Welcome to the weekly roundup, where we go in depth in a particular topic. My name is James VHIA. I'm a workplace relations advisor at the VHIA. I'm joined with my colleague, Emma Scott, Senior Workplace Relations Consultant.
Hey James.
Here we are doing a podcast, and I take that the next part is to discover what the clue is.
Yes, I have pre-prepared a clue about today's podcast topic that you'll be interviewing me on, so Come on, get with it.
Okay. Oh.
Okay, so could you hold it up to the camera and explain the clue that we've got for people watching or listening?
So this is the clue. It's a Yammer post by you, Emma.
Yep, it is.
Our platform online, our social... Actually, it looks like social media. Social interaction.
Yep, so you've got the topic pretty bang on there compared to when I guessed them. So the topic that you'll be questioning me on today is social media.
Okay. Oh, cool. So what is social media?
So based on the Macquarie dictionary, social media is online social networks that are used to disseminate information through online social interactions. And when I say online interactions, it's not just internet, it does also include telephone-based applications.
Oh, okay. That's interesting. Seems quite broad. How long has social media been around for?
So before researching the podcast, I would have actually thought the 2000s. But when I've looked into it further, it was actually in 1997 where there was a first social network introduced where people could do their own profiles and make their own comments. And that was created in 1997 and it was called 6 Degrees.
6 degrees.
Yeah, and the only reason why I'm really putting it in the podcast is because I think it's one of those useless pieces of information that members might get asked if they were to be on by Eddie Maguire on Who Wants to Be a Millionaire.
Yeah.
They might get asked that question. So,
in what year was social media created? And our members would boom right there and say 1997. I like it.
Yeah.
I like it.
You're welcome.
How does social media compare in the 90s to now? Has it changed much?
Well, it's actually increased a lot. So you've got new developing platforms all the time. So you've gone from MySpace, Facebook, Twitter, LinkedIn, Tumblr, and I think one of the most recent ones is more so Snapchat.
Oh, interesting. Social media includes the word social. So what does it have to do with employment?
So really it does depend on the particular circumstance, but generally speaking there's no right to freedom of speech for employees in Australian legislation, unlike other countries. So although there is freedom to particular opinions, they're also bound by contracts of employment or particular protections in legislation. But then again, for employers, it's really about not being able to overreach on interactions on social media that have no interaction or care for the employers. They're just not connected.
Yeah. So what are some of the risks that employers face as their employees will be using social media?
Some common social media activities that provide risks to organisations for employment usually occur when employees express their dissatisfaction with their job or employer, criticise their employer's actions, attack or make disrespectful comments towards colleagues or clients, breach of confidentiality, and share content of sexual nature to colleagues or clients.
Can negative comments or breaches of confidentiality form the basis of allegations of misconduct?
Yes, they can. Depending on the circumstances, they can form the basis of allegations of serious misconduct, where you've got them comments that are made that are inconsistent with the employment relationship, or damage the reputation of the employer in what you would call a public forum in social media instances.
Yeah. What about comments, let's just say, about other colleagues?
Well, there's also issues with that. It can lead to claims for bullying, sexual harassment, discrimination, or even defamation. There's several cases that have been before the Commission that really do deal with social media and unfair dismissals. Yeah.
That's interesting. You mentioned cases that have been heard in the Fair Work Commission. Have there been many?
Yeah, there have been several cases that deal with social media and employment. Predominantly the cases deal with unfair dismissal, but there also has been a case in relation to the anti-bullying legislation as well.
Of the decisions that have been made, are there any full bench decisions regarding the use of social media?
Yeah, there was actually a decision in 2011 that involved Lynn Fox versus Stussel.
Oh, yeah.
And that was a single member decision that was then upheld by the full bench in 2012, where the Commission found that the conduct of the employee on Facebook didn't constitute a valid reason for the dismissal, and also that it was unharsh, unjust and unreasonable. And then the decision was actually also held up in the Federal Court of Australia in 2013. In
summary, what was the conduct of the employee, and what were some of the original Commissioner's findings?
So there were actually a few that are that have got some context around the social media. The employee's comments about terrorism and the death of Osama bin Laden were an expression of his private view and was not intended to be public. Although the comments were distasteful, the employee had a right to freedom of speech, and his comments could not be characterised as a personal attack on the manager. The employee's comment regarding the manager as a bacon hater was in poor taste, but was not racially derogatory and was not intended to be hurtful. When the Facebook comments were read in sequence and as a whole, the exchanges had the flavour of a group of friends letting off steam and trying to outdo one another in being outrageous, and a conversation in the pub or cafe, although conducted in an electronic format. The comments of a sexual nature concerning another employee were outrageous, but most of them were not made by the employee, but by others in the course of comments in a conversation on the employee's Facebook page. The employer's comments, which triggered the other employer's initial complaint, might have been disgusting, but they were an attempt at humour and did not contain any credible threat to her well-being. And Linfox did not have a policy on the use of social media by employees.
So what does that all mean?
Well, the Commissioner, through his findings, decided that there wasn't misconduct that occurred, and so therefore there wasn't a valid reason for terminating the employee.
The other aspect of the case that you mentioned was the decision that the termination was found to be harsh, unjust, or unreasonable. Why is that?
Well, the Commissioner took into account other circumstances, which is something that they have to do under legislation. So part of that also included that there were some other Linfox employees that made comments on the particular post, but they were not subject to any disciplinary action. So in terms of people being treated fair and in the same way, it appeared that that wasn't the case. And that really, there was considered about the employee's record of employment, and then their age and likelihood of getting employment elsewhere.
Is there anything else important about this case?
I think it should be noted that members realise that the comments that the original Commissioner found in regards to it being a pub-style conversation, that was disagreed by the Fair Work full bench, and that they said that really social media is a bit of a broader context in terms of it can be public and disseminated wider than just what you might call an old school pub conversation.
What else did it highlight?
Really, they made a note that discriminatory, offensive or derogatory comments made on social media sites by employees about other employees or their employer may be sufficient grounds for termination, and that in each case, the inquiry as to the nature of the comment and statements made and the width of their publication. So they're all matters that will decide if a case is in an employee's or an employer's favour.
Oh, that's interesting. What else did they highlight about the future of social media and what it entails?
Well, they said that obviously it's going to become increasingly widespread and employers will be starting to put policies in place. So in terms of the case that was decided, it was talking about the person's lack of knowledge about the privacy in regards to their comments, and that may start to actually not become a reasonable mitigating factor because employers will have clear policies in place about expectations. So they highlighted that.
So the case you mentioned relates to conduct and decisions that occurred from 2011 to 2013. What about more recent cases?
There are more recent cases. The most recent one that I found in the research is when it comes to a single member decision, which is Natoli versus Anglican Community Services.
What did that case involve?
So as a result of a workplace incident, a supervisor had a belief that one of their subordinate employees damaged a car that they drove and parked at work. What
did the supervisor do?
So the supervisor posted a photo of the damaged car and wrote on their Facebook, and I quote, "A nasty piece of work in my workplace decided that she would teach me a lesson by scratching John's $60,000 vehicle, which I was borrowing yesterday. The little didn't like being told to complete her duties before month end, so this is the result. John's rightfully furious, and so am I. Watch out. This is over $6,000 damage." The supervisor also liked her then partner's comments, which read, "Wait till I get my hands on you, you fat piece of shit." The supervisor also sent text messages to the employee as well.
Did the supervisor admit the conduct?
Well, the supervisor did admit that the text messages were intended to scare and offend the subordinate employee. However, they denied that the overall conduct was threatening or intimidating.
How did the supervisor come to the conclusion regarding the overall conduct not being threatening or intimidating?
Well, this really related to the social media posts on Facebook. So they took into consideration or were arguing that the Facebook post didn't name the subordinate employee, and it was posted to a closed group of the supervisor's friends, and that the post was removed a week later when the supervisor realised that it could have been construed as threatening, and that also that they said that they weren't aware of the social media policy of the employer and didn't receive training on the policy.
What else did the supervisor rely on?
Well, the supervisor largely relied on saying that it was a once-off incident, that they were dealing with workload stress, and that their good record shouldn't have been tarnished by just a once-off in the heat moment of a comment.
Yeah. So what was the Fair Work Commission's final decision?
So in summary, the Fair Work Commission rejected the employee's explanation that the conduct was a spur of the moment and found that it was deliberate conduct that was offensive and unacceptable in circumstances where the supervisor was at home without the diversion of work and had time to consider her response to the subordinate's denial of the allegation. They rejected the supervisor's attempt to downplay the threat in her messages to be grasping at straws, and that the motivation of the conduct was clearly to scare, intimidate and threaten the subordinate employee. They weren't satisfied that the supervisor had demonstrated any level of remorse, particularly as she had not apologised to the subordinate employee and did not delete the Facebook post until 1 week later. It didn't consider that the supervisor's acknowledgement that the conduct was not ideal amounted to remorse, and even so was likely done in the interest of saving their job, as opposed to any genuine attempt to recognise that her behaviour was unacceptable. And really, they rejected the alleged lack of knowledge and training. The belief that the argument was designed to deflect that any reasonable person would believe to be offensive and threatening conduct to the subordinate employees.
So the Fair Work Commission held that there was a valid reason for this dismissal?
Yes, so in this particular case it found that the misconduct occurred and that there was a valid reason for the dismissal.
And it wasn't found to be harsh, unjust or unreasonable?
No, it wasn't. The Fair Work balanced the matters such as the supervisor's 11 years of service, where they'd only had one incident of a complaint or disciplinary action, against the seriousness of the conduct and the lack of regret. They were satisfied that it wasn't harsh, unjust and unreasonable, either substantially or procedurally. Therefore, it was dismissed. Yep.
Oh, interesting. From the two cases we have gone over, what are some observations that can be made?
Really, it confirms the statement that just because it's called social media doesn't mean that there isn't a link that can be made to employment, which you can see in the second case. However, how it does link is quite a complex topic that is evolving over time as the platforms, employees and employers' behaviours, adapt or take into account, the real reality of where places are going with social media. Yeah.
Oh, interesting. So there haven't been any finalised cases regarding unlawful termination on the basis of terminating employees for preaching political or religious views at the Fair Work Commission?
No. So from the research that we conducted, there wasn't particular cases there where there were final decisions. However, that doesn't say that there wasn't actually, allegations made. Yeah. For example, in 2018, Cricket Australia terminated an employee for allegedly making comments that contravened the organisation's policies in regards to statements, and those employee statements were about abortion rights in Tasmania. So the employees' legal team were going to argue that those beliefs were political beliefs and that they had a right to those beliefs, but that was actually settled out of court, so it never actually went to the Fair Work Commission.
Is the Israel Folau case another example?
Yes, it is another example. It's an example based on religion. To date, it's quite in the media and you can see that it hasn't actually settled. And everyone is waiting for bated breath to kind of see if there is an outcome and it does go to the federal court, because it could prove to be an important test case where matters regarding social media, contracts of employment and protected attributes become clearer mud. So really you're dealing with two competing employment considerations where you've got rights of employees to express opinions and then rights on employers to defend, their values.
Do you have any advice for employers, or being more specific, our members?
So we do advise members that really when they are considering any kind of disciplinary action or termination of employment when it comes to social media, that they contact us for advice, because it is a hard area to look at between the links between the social media and employment and the various type of conduct that and situations that employers face. But we also like to make sure they have up-to-date social media policies that take into account, the updated relevant case law.
Yeah, interesting. And I'm very much looking forward to the outcome of the Israel Folau case. I think it'll be all over the headlines, and I'm sure we'll keep members informed with how that case progresses. We'll no doubt publish the outcome of that on our VHIA platform.
Yeah, so if it does go to, a court decision, so far we haven't made any comments on our app, but if it does go to, say, further in court where you've got the arbitration or the federal court, we'll definitely be updating members on VHIA. So, as a result of that, it's really important that members go onto VHIA to make sure they're up to date.
Well, that concludes our podcast. Emma, thank you so much for your responses today. It's been great.
That's okay. Thanks for letting me answer the questions. It's definitely an interesting topic that's, ever evolving, and hopefully the discussion helps our members.